they were never made. You know it's real, and something that you really feel. Down in the bottom of your heart, it's
Back in 1998, the Supreme Court of Canada issued a landmark decision regarding Quebec's potential secession from Canada. The court ruled that Quebec cannot unilaterally secede under either Canadian or international law. This was known as the reference-re secession of Quebec. This followed the 1995 Quebec referendum, in which citizens were asked whether Quebec should become an independent country. The result was extremely close, with approximately 50.6% voting no and 49.4% voting yes. Although Quebec remained part of Canada, the referendum raised the legal question. Could Quebec legally declare independence on its own? The Supreme Court answered no. Under the Canadian Constitution, a unilateral declaration of independence is not legal. Secession would require negotiations involving various branches of the federal and provincial governments. Under international law, the right to self-determination typically applies only in cases of colonial rule, foreign occupation, or oppression, none of which applied to Quebec. The court emphasized that federalism, democracy, the rule of law, and respect for minority rights are fundamental principles of Canada's constitutional framework. This decision led to the creation of the Clarity Act in 2000, which set conditions for any future referendums on sovereignty, requiring both a clear referendum question and a clear majority before any negotiations on secession could begin. But now you know.
Folks, so welcome to our latest video. Today we're going to be looking at our continued approach to the rights and freedoms within Canadian law, and we're looking at specifically the Oakes test. This is one of the first sort of major challenges to the Charter, and specifically we're looking at Section 1, the idea of reasonable limits of our Charter rights. So looking at Section 1 here, this first part of the talk is about the idea that how does it both guarantee and limit rights? Well, Section 1 of the Charter establishes that every single Canadian is guaranteed rights protected by the Charter. We already knew that, of course, but simultaneously it provides the possibility that these rights can be limited. So the government has the possibility and the capacity to limit your rights if the limit is demonstrated to be justified in a free and democratic society. So if there's a reason for limiting your freedom, they can do that. Right? So that's something to consider. So we look at programs like the MAD program, the drunk driving program, whereby people are stopped and then the officers do the spot checks on the road. That is infringing on your rights in some ways, but it's a reasonable and justifiable infringement because it is generally considered a safer and better protective system for everybody within society. So looking at question 2 here, you talked about the idea that why does the government have to justify limiting a person's rights? Well, that's fairly self-explanatory, I think. The Charter is in place to ensure that rights and freedoms of Canadians are protected, of course. So requiring the government to justify any Charter infringements ensures that these rights and freedoms are not arbitrarily limited by the government. So the government can't just do what it wants and infringe your rights whenever it wants. This is the significance of the Oakes case, the RV Oakes case, is that this is a Supreme Court ruling that establishes the Oakes test, which is the sort of shorthand way of looking at whether the infringement imposed by government is justifiable or not justifiable. So essentially, this is what Section 1 analysis looks like. This is a broken down version of the Oakes test, a simplified version. So if you were looking at a potential rights case or potential charter challenge, you would just discuss the idea of whether the law is pressing and substantial. Right? Is the purpose of this law important enough? Because ultimately that's what we want to see, right? So is the law's goal pressing and substantial? If it is, yes, then move on to the next one. Is the law rationally connected to its purpose? So if it's about protection for people for drunk driving, we want to make sure the purpose is connected to the law itself. It has to be rational. Does the law minimally impair the infringed right? So if you are found that the law or the change to the law has been infringing on your rights, the court wants to make sure that it's of minimal impairment. So if your rights are infringed, we want it to be as little as possible, and that makes sense, I think. Then we have to look at the positive outweighing the negative. And obviously, if the infringement is more positive than negative, it could potentially be justified. Ultimately, if you're looking at all these different questions and the answer is yes, 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 we could say yes, the infringement is justified.
like they were